Everyone, today is May 13th, 2020. This is a quasi-regular meeting of the members of the State Liquor Authority being held in Albany with Commissioner Ford. Commissioner Ford, are you there, please?
Present.
And Commissioner Fan?
Yes, I'm here.
Both participating by telephone. Here in Albany, we have Chairman Bradley, and staff is Deputy Commissioner of Licensing Roberts, Counsel to the Authority Meyerhoff, myself, Secretary to the Authority Donahue. The next meetings of the members of the Authority will be May 27th, June 10th, and June 24th. It's anticipated at this point that those meetings will be held as the last few meetings pursuant to the Governor's executive order. They're being done with the members participating by telephone, and there are no personal appearances by those who have matters before the members. Everything's being done on paper. With that, Chairman, do you have anything else before we get started?
No.
Okay. We're going to call items for the most part in the order that they are listed on the agenda. However, we're going to take a few matters out of order, starting with item 655C, Match Place LLC, which is a request from Counsel's Office for an emergency summary order of suspension.
Good morning, everyone. This is a proposed emergency suspension based on a violation of Executive Order 202.3 concerning the restrictions against restaurants and bars serving on premises. The licensee is Matt's Place LLC, a bar tavern at 1235 County Road, 16 Beaver Dams, New York. That's Schuyler County. The principal of this location is Matthew Odell. This is a matter that came to us based on a complaint sent directly to the SLA. Our enforcement responded, and on May 7th, our investigator, Mr. Klassen, began by sitting outside for 15 minutes where he observed cars coming and going, people going inside and coming out, not coming out with takeout orders. After the observation period, he entered the premises and observed 8 to 10 people seated at the bar, consuming bottled beer, canned beer, and draft beer. He asked to speak to the owner. A female directed him to Mr. Odell, the principal. He was behind the bar at the time. He spoke to Odell, disclosed his identity, informed him that he was in violation of the governor's order. Mr. Odell first said that he thought it was okay to serve drinks while people were waiting for food orders. Note that that wasn't really what was going on in the location. As observed by Mr. Klassen, people were leaving without food orders. Mr. Klassen explained that it didn't matter, which it doesn't, although that is the common excuse that people who are caught make. And in response to being told that that didn't matter, Mr. Odell became hostile, and he said, "This is bullshit. No one in this county has the COVID virus." Mr. Klassen provided him with a copy of the executive order. He responded that the order was not a law and would not hold up in court. Mr. Klassen informed him that he could serve food and alcohol for takeout, making sure his patrons left the premises, and Odell responded by saying he can't make money that way. Mr. Klassen also then started to feel some hostility from the patrons who were focusing on the conversation and glaring at him, so he left. And he put in a call to the Schuyler County Sheriff's Office to report what had happened. He was surprised, I don't know whether he was surprised, but they explained that they weren't taking direct complaints about these incidents and directed our enforcement to the New York State Department of Health hotline. This is a different experience than we've had in just about every other circumstance that this executive order has come up, where law enforcement has not only been cooperative, but has been proactive, and certainly when we see an issue has gone to the locations and written up reports or warned the people. So that's one of the reasons why in this case, as separate from some of the others, we don't have police reports or summonses here. it appears that law enforcement out there isn't enforcing this order. That doesn't make it any less of a violation. Those are just the facts. What we have here is a licensee who initially lied about what was going on inside, then got hostile, and then said essentially that he will not follow this order because he couldn't make money, because it's not enforceable, and because he thinks it's bullshit. And he also said that there are no positive cases in that county. That's actually not true. Although I won't say that there is just as imminent a threat in this county as there is in every other county. But the question, respectfully for the members, is where you draw the line, and what risk we're going to allow. And I would point out that the governor's executive order doesn't say we're only going to have this restriction in counties that don't have a lot of activity, COVID activity. Apparently, the governor signed this executive order because he thought it was an imminent risk to health and safety if people did not stay out of these restaurants everywhere in the state. And counsel's office believes that this case, like the others, where there have been suspensions, falls into the same category. That the members really can't have a confidence that the location will enforce the executive order, and that is itself an imminent threat to public health, welfare, and safety. And for that reason, counsel's office requests that the members summarily suspend the license.
Commissioner Fan, do you have any questions?
No, I do not.
Commissioner Ford.
So, counsel, we only had the one visit. There's not been any follow-up visits as there have been in most other cases that have been brought before us. Is that correct?
Well, actually, as in most cases that have been brought before us, the police are usually involved, or some subdivision of the county. So we have none of those visits here. All we have is our own enforcement visit. And in answer to your question, yes, this is based on the one visit that our enforcement investigator made to that location on May 7th.
Right. So, like you said, it is an abnormality that the law enforcement referred us to a hotline. So, obviously, they're not participating in being cooperative here. So it's likely we couldn't depend upon them for follow-up enforcement anyway. All right, I'm good. No more questions.
Chairman Bradley.
Yeah. So is it fair to say that the owner of the bar made it clear that he wasn't going to follow the executive order, whether we did a second visit or not?
Well, he didn't.
He blatantly said that the executive order is blank bullshit.
He didn't say that he would not follow it in the future, but he wasn't asked. In the ordinary course, what law enforcement would do in a situation like that is get maybe some more information about how cooperative he would be, because they would then seek to disperse the place and get rid of the customers. But we just had a sole investigator inside. He felt like he was in potential danger because of the hostility in the place, so he left. So we didn't even get that input. So all we have to go on is his statements that he thinks it's bullshit. He doesn't think the order is enforceable because it's just an executive order, and he can't make any money that way. And I'm saying, from our perspective, from counsel's office perspective, that I think that the board should assume that he will not follow it.
And it's clear. I guess the point I'm trying to make was it clear that this wasn't a mistake or a misunderstanding of what the executive order was, what they were told to do?
I don't think so, because he initially attempted to defend his conduct by saying, I thought I was allowed to serve. I mean, he initially lied. And look, the reason we were there wasn't because we just happened upon the place. Neighbors, somebody who saw the place open, complained, and that's why we went there. We field these complaints frequently, and we send our enforcement team out there, or we coordinate with local law enforcement, or both.
Okay.
In this case, we just sent our investigator out.
All right. And go ahead. I'm done.
Commissioner Fan, your vote, please.
Yes, this licensee has clearly violated the Executive Order 202.3, and I'm going to vote to summarily suspend this license because of imminent threat to public safety, health, and welfare.
And Commissioner Ford.
I'm going to vote to summarily suspend as well. He has made it clear he doesn't believe that the order is righteous, just, or lawful, and gives every indication he has no intention of complying with it. So I vote to suspend as well.
Chairman Bradley.
I vote to summarily suspend as well. I mean, I get it. At this point, it's been weeks, and people are trying to salvage their business, but his one statement that there's no COVID in the county is clearly incorrect. There is COVID in every county in New York State. There is certainly in Schuyler County there are cases. These executive orders were put in place in order to protect the public, and it's obvious that he has no intention of complying with that executive order. So I don't see any other choice than to make sure that he is not open. So I'm going to vote to summarily suspend.
Yeah. Commissioner Fan and Commissioner Ford, if you could, we're getting a lot of feedback, so if you could mute your lines until you're speaking, that would be helpful. All right, the next item is 655D, Mr. Quigley's Inc.
Members, this is also a proposed emergency order of suspension for Executive Order 202.3. Mr. Quigley's is a restaurant bar tavern located at 635 West Avenue in Lockport, New York. There's one licensed principal, Michael Carrier. There's also a general manager listed on the license, Nancy Carrier, who is the spouse of Mr. Carrier. This case began after a media inquiry because a fight was reported from inside a licensed premise on April 10th. Lockport police responded to the premises on that day, April 10th, at about 7:30 p.m., and the incident was actually reported by Mrs. Carrier, the general manager, that a female patron threw a punch at an employee. When police arrived on the scene then, 5 individuals were present. The manager, Ms. Carrier, a cook, and 3 individuals who appear to be patrons. One of the patrons was being restrained because she threw a punch at one of the others. And the officer determined on the scene, as his report reflects, that the parties appeared to be intoxicated and had been drinking at the bar for an hour or two. 2 admitted to that. The third denied it, but was breathalyzed and had a 0.1 blood alcohol content. Our investigation then led us to the building inspector in Lockport, Jason Dool, who told us by the phone that he had been to that business a few days before then on April 7th because he had received complaints about on-premises consumption and had spoken to Nancy Carrier, who advised him that the business was open for takeout only. So that was the status of this case when counsel's office learned of it originally, and we issued we issued charges for violation, but because we didn't have any evidence that they had been warned in advance, at least in this circumstance, and the possibility that this would be a one-time event, we did not believe it necessary to bring it to the board for a summary suspension, which has been our practice. But interestingly, it appears that another complaint may have been prompted by that charge because the mail for that charge was delivered on May 8th by the United States Postal Service, and the timing suggests that just minutes after delivering that mail, a complaint was registered that there were people drinking inside. We don't know for sure, but it may very well have been the Postal Service employee who dropped the dime on this place and called Lockport police to say that there is drinking on the premises again. So that's May 8th. And the Lockport police went back to the same place. Upon arriving, they observed the same woman who had warned before, manager Nancy Carrier, and 3 patrons inside the premises drinking at the bar, beer bottles and glasses of alcohol on the bar. She was standing behind the bar and was heard yelling, quote, "The cops are here," and then tried to hide the drinks behind the bar. She then told the patrol that the customers were just waiting for fish dinners. She later admitted to the customers that they had been drinking in the bar. So we spoke to Jason Dool again. He advised that the formal violation notice was issued for the premises. This is the building inspector, and that was on May 8th. He stated that he'd given Nancy Carrier 2 verbal warnings before issuing the formal violation. We then generated an amended notice of pleading, adding these new charges to the initial charges, and now bring the case to the board for a summary suspension. The licensee's manager here is the wife of the owner. Whether they speak to each other and he had actual knowledge of the warnings that his wife, the general manager, had received, or didn't have actual knowledge of those, it's still a violation in our view that warrants a suspension, because either he knew and allowed it to happen, or he's so abandoned supervision of the premises that we can't count on him to ensure compliance with the order. The general manager added fuel to this fire by allowing patrons to remain on the premises for extended periods and become intoxicated, leading to a fight. She tried to hide her knowingly improper conduct by shouting, "Oh, look, it's the cops," and trying to hide the alcohol. This is a place that we believe the members can have no confidence that will adhere to the executive order and other requirements of the law, puts it, public health and safety at imminent risk, and should also be summarily suspended.
Commissioner Fan, do you have any questions?
No, I do not.
Commissioner Ford?
No, I do not.
Chairman Bradley?
No.
All right then. Commissioner Fan, your vote, please.
Yes, I vote to summarily suspend this license. There is clear evidence that this licensee has violated Order 202.3. Imminent threat to public safety, health, and welfare. I vote to summarily suspend.
Commissioner Ford?
I vote to summarily suspend for the same reasons as stated by Commissioner Fan. Authorities arrived there and found patrons inside, intoxicated, having been obviously drinking for a couple of hours. Obviously, police did show up before. They were yelling for to everyone that the cops are here to, vamoose. So obviously they knew what they were doing and trying to hide from doing something illegal. So I vote to summarily suspend as well.
Chairman Bradley?
I vote to summarily suspend as well on the basis of both commissioners' statements.
All right, the next item then is 655E, Loopy's Pub, LLC.
This is a third proposed emergency order of suspension for Executive Order 202.3 violations. The location here is Loopy's Pub, LLC, a tavern located at 410 Mohawk Drive, Tribes Hill, New York. Sole member of this location, of this licensee is the sole member of an LLC that is the licensee. Mary Lou Crane is her name. So Montgomery County Sheriff's Office got involved here based on a number of complaints and an undercover visit, but the issues here go back to March 19th, which was the week the order was passed, the executive order, when the SLA got on the phone with Ms. Crane, supervising investigator Bart Gottesman from the SLA's Enforcement Bureau called Ms. Crane because the authority had received complaints that they were inviting people to come in by advertising on social media that they were still holding games of pool and darts, etc. And he advised the licensee that they could not do that. He warned them that enforcement action would be taken if they were found not to be complying with the executive order, and she acknowledged to our investigator that they would just be doing takeout only. Then in late March or early April, the sheriff of Montgomery County, Jeffrey Smith, directly warned Miss Crane himself that she was violating the order and needed to not do so. Called her on the phone because he had been receiving complaints about patrons gathering and consuming food and beverages inside. He told her he didn't want to take legal action. Miss Crane stated to the sheriff that she was not allowing anyone to consume food or beverages on the premises. They were only doing to go, and she indicated she understood the executive order. Sheriff Smith also counted the county executive for Montgomery County, and because he's a friend of Miss Crane, and according to police records, the county executive also called her and had a detailed conversation with her, and she told him the same. Well, the complaints continued, and that caused the sheriff's office to not only warn her again on April 17th, but to decide to do an undercover operation. So on the 17th, they got a complaint. The sergeant responded. By the time they got there, they did not observe anybody consuming on the premises. Maybe they had left by that time, but gave her an additional warning. And then on May 2nd, they sent a confidential informant inside with a video and audio device. There were 5 people seated at the bar, 2 seated in the dining area, a male standing using his cell phone, and Miss Crane was serving these patrons food and beverages and inside the premises. So 9 total people inside. She was also heard commenting about the fact that she could be fined for being open and that she's pushing it. The CI ordered food and alcoholic beverages, consumed them on the premises, and remained in there for approximately an hour. In summary, excuse the pun, repeated warnings here. She apparently lied to the sheriff and the county executive about her intention to comply. The only way she was caught, she was caught after being warned for having people there by an undercover officer who sat there for an hour and observed 9 people inside. This licensee clearly doesn't take warnings seriously, doesn't take the executive order seriously, and is conducting the licensed premise in an inexcusable manner. This is an unnecessary and completely avoidable risk to public health and safety. She's indicated that she will not take it seriously. The members can't have any confidence that the health, welfare, and safety will be protected of the public, and we ask for a summary suspension on this one.
Commissioner Fan, any questions?
No, I don't have any questions.
Commissioner Ford?
I don't have any questions either.
Chairman Bradley?
No questions.
All right. Commissioner Fan, you ready to vote?
This licensee has clearly made a conscious decision to challenge the executive order, and there's clear evidence that he violated the executive order 202.3, and for that I vote to summary suspend their liquor license due to imminent threat to public health and welfare.
Commissioner Fan, we got a lot of interference with your vote when you were explaining your vote. So could you just kind of go over it again, please?
Yeah,
and if you had just there seems to be some background or some echo there.
From my room?
Yes.
Or a bad connection.
Or a bad connection, right.
Or if you're on speaker, I don't know if you're on speaker.
Is this better?
Yes.
Yes.
But there's some squeaking that I also hear. It's not from me. Okay. Anyway, so there's clear evidence here that this licensee violated the governor's executive order 202.3. This licensee has clearly made a decision to challenge the authorities on this COVID crisis, and for that I vote to summarily suspend her liquor license, and because of the imminent threat to public health, public welfare, health, and safety.
Commissioner Ford.
Hey, Commissioner Fan, when you said you were hearing some squeaking on the other end, I muted. Did it stop at that point?
Yes, it did.
Okay, all right. I'll do it again as soon as I'm done talking. The sheriff called the licensee twice, sheriff's office. Sheriff Smith, at least himself, one time personally. He even had the county executive call to warn them. So I think it's pretty clear that there was never any intention to take the warnings and advice seriously, and we can't depend on her to follow the order, so I vote to summarily suspend.
Chairman Bradley.
I vote to summarily suspend on the same basis as the other two commissioners.
All right, the next item we have 655F. This is also a request for emergency summary order suspension regarding Water, Inc.
Yes, Executive Order 202.3 is the reason as well. Water, Inc. does business as Bourbon Street of Monroe at 78 Mill Pond Parkway, Monroe, New York. The licensee's sole principal is a Scott Benoit or Benoit. I don't know how he pronounces it. In this one, the licensee, the Monroe Police Department visited the licensed premise on April 29th after receiving complaints that the customers were gathering inside. Officers observed 8 patrons sitting at the bar in close proximity to each other, consuming alcoholic beverages. In addition to the 8 patrons, there were 3 employees behind the bar and walking around the LP. So Sarah Benoit, who is named as the owner in the police report, so I assume she identified herself as the owner, and is likely Scott Benoit's wife, not a principal, indicated that most of the customers are picking up takeout. That was her response to the police. Most of the customers have been picking up takeout. But she did admit that they had been allowed to sit in the bar and order drinks. The officers advised Ms. Benoit that it doesn't matter, violates the executive order. She stated that she would comply moving forward. And then the officers left, and 2 hours later, one of the same officers drove by and saw one person sitting in the bar through the window. On May 3rd, 2020, which is 4 or 5 days later, the police were again dispatched to the licensed premise. Social distancing complaint again. This time, the licensee's principal, Mr. Benoit was present. He told the officers that the patrons were waiting for takeout. There were 4 people sitting in the bar holding alcoholic beverages. So 4 or 5 days after the warning, they were doing the same thing. So in this case, the licensee's wife, apparently in charge of the licensed premise at the time, she essentially admitted that she permitted patrons to consume alcohol at the bar. She even said most customers were waiting for food, which is, a kind of a half-baked purported defense, and actually an admission that some weren't waiting for service, and she had no problem serving them. But despite warning her and telling her why that was a violation, this licensee did not comply moving forward, and just a few days later, police had to go back and found the licensee there, and he offered the same excuse, which is a non-excuse. Having 12 people inside, as they did on April 29th, would just be too dangerous in this environment, but this licensee also showed that he does not heed the warnings, as he was caught again. Public health, welfare, and safety are at imminent risk when this executive order is violated, and we ask for a summary suspension.
Commissioner Fan, any questions?
No, I do not have any questions.
Commissioner Ford?
No questions.
Chairman Bradley?
No questions.
All right then, Commissioner Fan, your vote?
Very disturbing that this licensee has allowed multiple people to sit at his bar without masks and not practicing social distancing. It seems like that would be common sense at this point in the state of New York. I vote to summarily suspend this liquor license for clear violation of the governor's executive order 202.3 and due to the licensee's decision to create imminent threat to the public's health, safety, and welfare.
Commissioner Ford?
The licensee was first visited on April 29th when they found 12 people there, and they weren't charged at that point, but they were warned. And May 3rd, they went back again, found 4 patrons at the bar. I think that, as you said, after an officer drove by and noticed people inside. So it's pretty clear that they weren't listening the first time and aren't intending on heeding the warning and advice, so I vote to summarily suspend.
Chairman Bradley.
I vote to summarily suspend on the same basis as the other commissioners.
The next item we're going to take care of is 655B. This is a proposed advisory regarding the submission of renewal applications without the required fees.
So, as Secretary Donahue mentioned, members, before you proposed advisory regarding submission of renewal application without required fees. As you recall, on March 24th, the members approved and gave directive to allow renewals to be submitted without payment and that payment to be deferred until May 31st for renewals due in March and April. This advisory proposal seeks to extend the March and April renewals to July 31st, as well as include renewals due in May and June of this year for certain licenses to be deferred as well until July 31st.
I vote in the...
Okay, Commissioner Fan?
Yes, I vote to support this.
Commissioner Ford?
One question. It says the licensees may obtain an extension until July 31st, 2020 to submit the renewal fee if they can demonstrate financial hardship as a result of COVID-19. How do they go about doing that? Do they need to submit numbers or...
They can submit a hardship letter to our licensing.information@sla.ny.gov account, and we'll process their hardship request from there.
Okay. I vote to approve as well.
Chairman Bradley?
I vote to approve.
All right. Going back to the items as they are in order on the calendar. 618, which is a request for declaratory ruling regarding Hold'em chess.
Yes, members, this is a matter that was on initially back in December, and as you may recall, there was a lengthy discussion. The creator of the game was present and showed the members the pieces and described the game. This is a game that combines, to some extent, chess with Hold'em. It's like a board game that would be played in bars and restaurants, and just generally the players play chess, and their goal is instead of capturing pieces and ultimately the king of the other side, it's the pieces are then have cards represented on them, and the captured cards can then be put together as poker hands, and the players with the best poker hands are the winners. The board was actually going to vote that day, and I asked that the matter be held over because, as counsel, I was concerned about the state liquor authority commissioners who are, charged with dealing with the alcohol beverage and control laws, giving opinions of first impression on matters that concern the penal law, and issues of gambling under the penal law are, usually something that's a law enforcement matter. So I asked that we take a break and looked into whether or not that was a matter better served to be addressed by, a law enforcement agency, the Attorney General, or maybe even gaming. And in the middle of that break to discuss that, the third department actually entered third department court of appellate division entered a decision in the White v. Cuomo case, which is a case about whether or not fantasy sports constitutes gambling, and whether the statute that says that it doesn't constitute gambling is constitutional. That decision kind of further complicated matters on that. So that's why it was held over. It's back on the record here because I do have some further thoughts and direction on that. While I don't think it makes sense for the members to decide close calls in this area in the first instance for all of New York State, and that's my opinion, it's certainly up to you as members to decide what to do here. In clear cases where it's obviously gambling or obviously not gambling, That's certainly it may be something that the members can do. I think, although certainly happy to discuss this further with the members if they have any questions. This game, chess would be the kind of ultimate skill-based game. And then there's a continuum of games that may fall in between when you get to, something like, a number wheel, something that's purely random. There's certainly games in between that would be in the gray area. And given the standard here, which is, does the outcome depend to a material degree upon an element of chance, it's a standard that could be viewed as kind of amorphous and hard to determine. But on this game, I think there was, at least the applicant, the requester of the declaratory ruling made a strong case that this was really a chess game and not a card game. So, that's really just to set the scene where we are right now. And I think the members can decide whether they want to issue a declaratory ruling here or not.
So the cards that are assigned to the chess pieces, are they randomly selected by a dealer?
No, the game as it was represented to us is set up in advance, and each player plays the game from exactly the same position, although in a rotation format. So there is no randomness to the pieces you could acquire. That element of randomness is removed by recreating the same start, no matter which seat the players are sitting in.
Is it fair to say that the better player, that your skill level in chess will determine whether you're a better player than the next person in this game?
Yeah, that's my conclusion from it, because it really is like chess. I mean, in chess, the goal is to capture the king, and along the way to capturing the king, you kind of decrease the other side's forces by taking pieces, using your skill against the other side's skill. And there really is no randomness to it. It's just based on skill. Here, although the ultimate goal isn't to capture the king, it is to capture pieces in operating in much the same way. And when you capture those pieces, instead of increasing your chance of being able to get the king, requiring cards that have been assigned, and then you can tactically go after pieces that have the cards you'd want to make the best poker hand. So the poker aspect of the game isn't driven by the randomness of the draw of cards in a deck. It's just a different goal assigned to players who use their skill to try to achieve it.
Okay. All right, Tom.
Commissioner Fan, Commissioner Ford, any other questions?
I mean, should there be a vote whether we actually issue this declaratory ruling or?
There's two issues. First, are you going to issue a declaratory ruling? And then second, what position you're taking on the ruling?
Right. And the request is for a ruling on whether or not this game would constitute gambling under the ABC law. And the ABC law follows the penal law. And the penal law, really the only disputed issue on this one, is whether the outcome of this game depends to a material degree upon an element of chance. That is the definition of one aspect of the penal that's at play.
So with that, Commissioner Fan,
Yeah.
what's your vote then? Or your votes, I should say.
Counsel, can you just tell me again what section of the ABC law this is?
I'm sorry, I didn't hear the question.
Is there actually a mention of the gambling reference in the ABC law. Can I just pull that up really quick?
Yes, it's section 106, subsection 6, which prohibits gambling in licensed retail on-premises establishments.
Okay, got it.
And there is case law, I believe, that says that the penal law section 225 is what applies. Is that right?
Well, what happened was years ago, the authority, there's another section in 105 that applies to off-premises licensees, the same language, but essentially years ago, the authority since there's no definition of gambling in the ABC law, the authority adopted the penal law definition of gambling, and that was upheld by the courts.
Right.
And how was and legally, how did we do the? How did we adapt that? Is that actually in our ABC law code, or is that a reference by?
I don't want to speak.
No, I can just say it. So there is no statutory statement in the penal law, in the ABC law that says we follow the penal law. But the law is that we follow the penal law. In decisions years ago, the authority said that they were adopting the penal law definition. And one of those matters was litigated, and the court upheld the authority's use of the penal law definition because we don't have a definition. Plato's Cave, I think, is the case.
Yes.
I think it's the Court of Appeals in the mid-90s. So, I mean, just to further clarify, the penal law says that it's gambling if it basically has three elements. If it's a contest of if you're risking something of value, it's a contest of chance, and you can receive something of value if you win. And then the penal law defines contest of chance as something where the outcome depends to a material degree upon an element of chance.
So with that, Commissioner Fan, are you ready to vote?
Yes. I mean, if gambling is not actually defined under the ABC laws, I would actually vote to not issue this declaratory ruling.
Okay, Commissioner Ford?
I'm going to vote to approve it as well. I'm not quite sure. I'm not quite sure that it's in our wheelhouse, but
Commissioner Ford, just for clarification, you're saying you're going to approve. Are you voting not to issue or to issue a declaratory ruling? And if you're voting to issue it, what are you voting to have the ruling say?
I'm voting to issue a declaratory ruling.
Okay. And to say this is not gambling?
To say that this is not gambling, yes.
Chairman Bradley.
I'm voting to issue the declaratory ruling and also voting to issue that this is not gambling. The outcome clearly here is based on your skill. As a chess player, it is not dependent on chance, in my view, in any material way. So I don't see how it would ever be deemed gambling under the penal law. So therefore, it's not gambling under our law.
Okay, then. Just to remind everybody again, Commissioner Fan and Commissioner Ford, if you can keep your phones on mute when you're not speaking. And I don't know if there's a phone in here that's going off or not. Somebody has chimed in that. Anyway, they were picking up some ringing. It may be from the.
It's councils.
All right.
Sure.
But anyway, so next
ESPN
item.
dings.
The next item is, or items, 619, 623.
So this is a conditional no contest, 2 proceedings, 3 charges in the first proceeding, 2 charges in the second. The offer is $8,500.
I vote to accept.
Commissioner Ford.
I vote to accept.
I
Chairman
vote to
Crowley.
accept.
Next, we have 620, Loose Lounge, Inc.
This is a conditional no contest. It's actually the first summary suspension that is coming before the board in response to violation of the governor's executive order in relation to the COVID-19 crisis. There are 6 charges. The offer is $25,000 to allow the licensee to reopen. I'm assuming that payment would be not deferred because these charges were...
Well, after you decide whether or not to accept the penalty, my question to the board would then be whether we would... You've already directed that no penalty letters go out.
Correct.
So my question to the board would be, is this going to be a modification of that after you decide you're going to accept the offer?
Okay.
Well, and although maybe it makes sense to talk about whether it's going to be accepted or not, but the one of the letters from Mr. Romano, who represents the licensee, says that they are willing to make the payment and not reopen until, I think that's what he says. I'll confirm that, but that we would not have to make that decision for everyone at this point as to whether or not we were going to make an exception and require these fines to be paid right now.
That's correct.
So,
I am reading his letter. If accepted as a condition of the plea, my client would not reopen the premise until such time as allowed under the governor's executive order, COVID-19 202.3.
right.
Okay.
So now, are we dealing with the offer then as being the $25,000 and not reopening?
Just do the offer first.
Okay. So Commissioner Fan, with respect to the offer of $25,000, accepting that?
I mean, I really think that, this licensee should have known better. On March 21st, there were already 44 deaths in New York City that was reported for COVID. So it's very irresponsible that they were open for business during this time. But I also, I'm really not I really don't want to take their license, so I'm going to vote to accept because they have no adverse history.
But they do have adverse history.
They do have adverse history. And
Yeah, but they have, if they have limited adverse history, I should say.
Commissioner Ford?
I might be willing to accept the $25,000, except for the fact that the police were there March 17th, March 19th, March 20th, 21st, 22nd. It's kind of like they were flipping them off, I would counter offer with at least $40,000.
Chairman Bradley.
So we're going to be in a bit of a quandary here because I am rejecting the offer. I mean, this was one of the earliest summary suspensions that we did during this crisis. And as Commissioner Ford pointed out, this was in the middle of New York City, and they were visited on multiple occasions. On March 19th, there were 30 to 40 patrons drinking out of cups and beer bottles inside the premise. On March 21st, there were 17 persons inside the premise. I mean, this order was well documented by that point in time. The crisis was beginning into the extreme at that point in time. It was going. The number of cases were going up exponentially each day. And it was obvious that this person had absolutely no intention to shut his business, as he was ordered by the executive order. And this isn't a business that's in Schuyler County where the individual made an argument that there were no cases. This is in the middle of the Bronx where there were people already dying. So I don't think there's any other option but to cancel this license. There were several bad episodes that we've encountered in this situation, but this was obviously one of the worst. So I don't see any option but to cancel and bond.
Now that the members have all given their initial opinion and they're all in 3 different places, let me just say one.
Well, we do have a vote. We have a vote to deny the CNC. So.
And then the question is whether or not there will be a counteroffer that there's.
And right now there won't be. So it would just be CNC denied, back to counsel's office.
Well, can I say something?
Yeah, but I'm saying that it's not.
Okay.
I mean, we do have a consensus for a vote.
Right. I would say this, that one of the things that the members need to consider, given that ordinarily you are dealing with circumstances where there's already a record on what kinds of discipline are afforded to different types of cases, and I believe that the members endeavor to try to make similar violations result in similar penalties. You have a relatively substantial list at this point of summary suspensions that one could say run the gamut between they're all serious enough for you to have voted to summarily suspend. Some of them are more serious than others. So I just state for the record that as counsel, in thinking about fairness overall, some assessment of where cases fit along the continuum, and charging. Similar discipline for similar conduct should factor into your decisions.
And to your point, Counselor, I was thinking along the same lines that we need to establish fairness and consistency with all of these. And this one, as the chairman said, was one of the more egregious cases, if not the most egregious case. So, I'm willing to reconsider my vote. Is that possible at this point?
If you want to change your vote, it's not. If you want to change your vote before we resolve this matter, yes.
I will vote to revoke as well. I think the chairman is right. They definitely don't deserve it, and they've. I don't think any amount of money makes it worth it for them.
Okay, so Chip, were you making a counteroffer?
Yes, of cancel.
Okay, so.
But if I'm going to revoke.
All right, so we have 2 votes to deny the counteroffer deny the CNC with a counteroffer of revocation and bond claim. And then, Commissioner Fan, you're accepting the offer.
Yes.
Okay. All right. The next item, 621, Fuller's Tavern of Cortland.
This is a new on-premises license in Cortland, New York. It's a tavern with 15 employees, 8 security guards, a principal to manage. They want recorded music, DJ, and dancing. The previous license at this premise was a summary suspension that resulted in a revocation because of 53 sales to minors, most of which were students at SUNY Cortland, many of which were freshmen and sophomores, based on their ages. The applicant's principal worked at the former place that we revoked and intends to use the same trade name. The principal has worked at other places in Cortland that have adverse history.
Commissioner Fan, any discussion you want to have, or are you ready to vote?
Oh, just to be clear for the record, the mayor of Cortland actually wrote a letter in support, And the applicant also wrote a letter explaining his history.
I just want to ask about whether we generally do this, where we issue a liquor license, but then allow them to be open on, as requested, Sunday, Monday, and Tuesday for rare events. Is that something that we do generally, or should we not? You know, it's like either they're open or they're closed.
On-premise establishments, they're allowed to set schedules as long as it keeps them bona fide with their method of operation. So we do allow licensees to set hours, days that they're established, because for some it just doesn't make sense to be open. But given
rare event. Sorry, Adam.
It's okay. Given the location, the history, and the applicant, it's all something that should be taken into consideration when deciding if that is something that we would allow.
You ready to vote then, Commissioner Fan?
Yes, I'm just not that comfortable with the way this is structured, because it's 15 employees with 8 security guards. And there's DJ patron dancing. It sounds like they're opening a nightclub that will be open only part of the week unless they have big events, that come in on Sunday, Monday, and Tuesday. So the application really doesn't make that much sense to me. The rent is $8,400. The investment is only $20,000. The application is it's not complete at best. If not, the licensee or the applicant really tried to, hide his involvement in a prior establishment that was at the same location. They also intend to use the same trade name. So it's just more of the same from before. So despite the letter from the mayor, which is unsigned, I'm going to vote to deny.
Commissioner Ford.
I was really interested in hearing from Chief Catalano, the chief of police, but we didn't get that. I get the letter from the mayor. Did you say that was unsigned?
Yes, and she's correct about that. It is unsigned. Although it came via an email from his email account. So.
Okay. We spoke highly of him, his military experience, all that kind of stuff. I think that I have reservations too about the name, but I do believe the previous licensee who lost it is still the landlord. Is that correct?
Correct.
So it's still the same landlord. The place is still the same place. That's why the investment probably is so low. There's not much for him really to do except get a better security system, which he's gone into detail about. And, he also said that most of the students that were there before that were busted, a good deal of them are either graduated or gone by now. And never
or 21.
So, what's that?
Or turned 21.
Or have turned 21 by now. Yeah. So, if the mayor believes in it strongly enough, Cortland doesn't have that much going on. No offense to anybody listening from Cortland, but and if they want to see a building occupied in a business as opposed to being empty, I'll go along with that. So I'm going to vote to approve.
Chairman Bradley.
So this place, we obviously shut it because of sales to minors, but prior to that, it had been open since 1994, and it had minimal adverse history during that period of time, right up until he had half of Cortland University in his bar. And this guy apparently was working there at the time, but it's obvious that something occurred that made him change his business practices. But, so I have concerns, much like Commissioner Fan did. However, the mayor signing on to this kind of puts the onus on him that if this happens again, and I have some level of confidence that we can put limits on this place to make sure that it doesn't get out of hand. So I'm going to vote to approve because of the mayor's support, and as Commissioner Ford said, Cortland probably has enough empty buildings, and if he could put a business in one, it would be helpful. However, I'm shutting it at 1 every night, security guards every night. The scanner that he has offered to use is mandatory, and no DJs, no dancing, no use of promoters. So he can have recorded music.
Commissioner Ford, with those limitations, are you okay with those?
Yes, sir.
All right.
If he shows a year of positive behavior through his business, then I certainly will consider giving more hours and music.
Next item, 622.
This is a CNC cancel and bond for 3 charges. That pretty much sums it up.
Cancel and bond.
Commissioner Ford.
Cancel and bond.
Cancel and bond.
Next item, 624.
This is a request to extend a conditional approval to September 1st of 2020. The conditional letter was issued on November 2nd, 2018, and it expired on 5/2/2020. They're requesting the extension because of construction delays due to COVID-19, which, whatever.
Commissioner Fan?
Yes, based on the supplemental materials that was going to vote to.
Commissioner Ford, could you try putting your phone on mute while she talks? Okay, go ahead.
That's right. Commissioner
Okay,
Fan?
I'm going to vote. Sorry,
Commissioner-
I'm going to vote to extend until January 1st, 2021 for an additional 8 months.
All right. Commissioner Ford?
I just switched to a different speaker. Does this sound any better?
Yes.
Okay, good. Yes, I vote to extend as well.
To January 1st.
Yes.
Chairman Bradley.
I do the same. January 1st, 2021.
Next item is 625. I would note I received a request from the applicant's attorney for the matter to be held over. I said I would pass it on to the full board. I asked if there was it has to be supplied with a reason for the adjournment. I had not received that.
I'm okay with the adjournment.
What'd she say?
Commissioner
I
Fan
said
is to hold it over.
Okay. I don't like doing this, but go ahead.
Commissioner Ford?
They didn't give any reason, huh?
No, I got the request. I said I would pass it on to the full board, but you would probably want a reason, and I did not get a response.
I'll give the benefit of the doubt this one time, just because of the current situation. So,
Chairman Bradley.
I'll give it. What is the date?
27.
27. 527.
So, and just going forward, because this is getting ridiculous. And we'll put this up on the website too. Unless there is a specific reason requesting an adjournment, meaning you're in the hospital, a family member's in the hospital, or some other specific reason that would be viable normally, we're not granting adjournments anymore. There's no reason for us to adjourn these cases because there's nobody supposed to show up.
Well, I would say that everybody, all the license applications are getting at least 2, and in some cases 3 weeks notice.
Yeah, and they've been filing the application for months, so there's no more adjournments after this hearing date. That everyone is on notice of that, and there's really no need. Mr. Flynn was not expected to be here today. He's had weeks, if not months, to give us whatever information we needed. And he, for whatever reason, didn't send anything in, so I don't see a reason why this would need to be adjourned. But I will go along with the other 2 commissioners and grant the adjournment, but now they're all on notice.
All right. And we will add something to the website to make that clearer. Next item, 626.
This is a new tavern wine license in Queens. The prior applicant had lost a temporary license because of violations while on the temporary. It's a tavern with recorded music and DJ, 5 employees, no security. The principal's to manage. There is also a DJ booth in the premises. The application, although says no security, in the next question they answer that there will be 2 to 4 security guards, so I don't know what that means. I'm assuming based on the first answer that there's no security.
Commissioner Fan?
I have a lot of questions about this application. I would like to find out if there's any relationship between this applicant and the prior one who lost the temp license. The finances, it's only showing $12.52. I don't even think the application fee is $12.52. I think just to get through this process is more money than that. So, and with that, I'm going to vote to deny.
Can I just say that for the record, there's a supplementary submission from the lawyer who says that there is, just states without any detail, no relationship with the prior applicant.
All right.
Commissioner Ford?
which would be other than being an employee, correct?
Right, and the landlord.
No.
He was not an employee. He was
No, she was a bartender or waitress for 6 years, but not
at this
location.
And the former applicant does not own the building. As far as I take it back. It does. Yes.
No, the licensee 2 licensees ago is the landlord.
Correct.
Yes, but not the one that was denied because he violated while on permit.
Correct.
Okay. The community board hasn't opposed the app. Again, as a state, the principal has no relation to the prior licensees.
Tavern wine.
I could have the same concerns that Commissioner Fan has voiced, but I'm going to give them the benefit of the doubt and approve.
Chairman Bradley.
I'm voting to deny. I mean, the thing that jumps out to me, which is obviously what jumped out to the other 2 commissioners, is they listed that they're investing $1,252 in a place where the rent itself is $3,500 a month, which means in order to get this place, they had to put $7,000 down that they decided was not an investment and didn't put it on their application. So That's without even getting any food or booze in the place before you open. He's investing $1,252. There's something going on here. I don't know what it is, but I'm not going to try to find out, so I deny.
Next item, 627.
It's a new on-premises license in Suffolk County. The previous two licenses here had significant adverse history. One was canceled, another was revoked. It's a 3-level place in a mall with 343 max occupancy, 141 seats at tables, 18 seats at bars, 19 seats at a dining counter. Has some level of government support from a couple county legislators, as well as some other local businesses. It's a restaurant to be managed by the principal and an additional manager. There'll be 10 employees, recorded music, no jukebox, no karaoke, live music with dancing is going to be permitted, 3 security guards. The principal appears to me to have no experience. They are not on a temp.
Yeah, and the supplementary says offers hours of 11 to 10 on weekdays and 11 to 12 on weekends.
Correct.
Commissioner Fan.
While this applicant has no experience, it seems like he's spent a lot of time and energy and money on the location. And he also has multiple letters of support from various county legislator and other businesses and neighbors, etc. So I don't know at this point whether he plans to open this place, but I hope to be able to be in support of his efforts. I will vote to approve for midnight hour, 7 days a week, security as needed, no live music, recorded music only, and a manager and 10 employees.
Just to be clear, Commissioner Fan, when you say recorded music only, so no DJ, no jukebox, no karaoke?
Yes, no live music, no dancing, no promoter.
No, nothing.
Just recorded music.
And I agree with her.
The RA restaurant.
Commissioner Ford.
With the support of Brentwood Chamber of Commerce, Suffolk County legislator Leslie Kennedy, and others, as Commissioner Fan noted, I'm willing to approve as well.
Approve with those conditions.
With those conditions, yes, sir.
As am I. Can we take 2 minutes?
All right, we're going to take a brief recess. It's now 11:17. It's now 11:24. We are back on the record. Commissioner Fan, you still with us?
Yes.
Commissioner Ford?
Still here.
All right. The next item is 628.
This is a Queens new on-premise license. The current and the two prior licensees have significant adverse histories. One got canceled. The current license is in safekeeping and has been since February of 2020. This is an exotic dance club with exotic dancing, topless dancing, 2 to 3 security, 6 to 8 employees. Principal will manage. They want recorded DJ, and the principal does have experience managing a exotic dance club.
Commissioner Fan?
He is on a temp, and there's been no issues with the temp.
I have some questions about how he runs a strip club with only 6 to 8 employees. But that may be the only thing I'm concerned about. And since they've been running with a temp, and when things reopen, probably this establishment would be very welcomed by the community, so I'm going to vote to approve.
By the way, the temporary permit has only been, it was 5 weeks before the restrictions were imposed.
And
So
when does the temp expire?
Well, the temp is in place, but there is nothing going on there other than perhaps takeout service.
Yes, of course, I understand that. But usually when we issue a temp, it goes until when?
So this one is already expired. It ran from February 13th to May 12th.
Ah, okay.
Right, so they were
All
open for about a month before the...
Given that the license, the temp holder have experience running such establishment, I'm as comfortable as I'm ever going to get with just paperwork.
Commissioner Ford?
I'm willing to approve as well.
Chairman Bradley?
I'm willing to approve as well, although I'd like to see 4 security guards on every night instead of 2 to 3.
Commissioner Fan, Commissioner Ford, are you okay with that addition?
Yes.
Okay.
Yes.
Okay. Next item, 629.
This is a Nassau County grocery store beer and wine product license. The prior license had a summary suspension and revocation plus a 2-year proscription. And then another case, we canceled the same license for the record. They've been on a temp. This place has been on a temp since January of 2020. No issues. The principals of this applicant do not appear to me to be related to the former owners at all.
What is their relationship to each other, though? That was my question.
They look like mother, son, would be my guess, although I don't think they say.
Yeah.
Yeah, that's what I had written down, mother, son, question mark. But I vote to approve.
Commissioner Ford?
Excuse me. There appears to be no relationship to the previous tenants or licensees at this location, so I will vote to approve as well.
Chairman Bradley?
I'll vote to approve.
Next item is 630.
This is an Onondaga liquor store alteration in the city of Syracuse. Wants to add a 4,000 square foot premise that is right next door. And they say that the add-on will be used for 100%. 100% of it will be used for storage. that would make their store go from 9,800 square feet to 13,800 square feet.
No protest.
And no protests, right?
With no protest and the closest store being 1.7 miles away, I vote to approve the alteration and expansion just for storage purposes.
Commissioner Ford.
Yeah, with there's no protest. Plus, the other stores are doing business in the millions. Yeah, they're like almost across the street from the East Syracuse Walmart. So actually, right down the street from my office. I know the area well. I vote to approve.
Chairman Bradley.
I'm going to vote to approve.
Next item, 631.
This is a new Queens on-premise license, a sushi restaurant with 5 employees, recorded music, no dancing, principal to manage, closing Sunday through Thursday at 11, Friday and Saturday 12 a.m. The previous applicant at this location was denied for cause for selling without a license. They do not appear to be related to the current applicant. The applicant was the chef/manager for the former licensee at this location, which did not have, which had minimal adverse history.
The restaurant's been open since July.
Right, and it is a 500-foot case. We don't really have anything from the community board.
Commissioner Fan.
Yes, and since the ALJ has found that the applicant has met the statutory burden of demonstrating public convenience, I will vote to approve with the hours of Sunday to Thursday until 11, Friday, Saturday until midnight, and recorded music only, no dancing, principal will manage, no promoters.
Commissioner Ford.
I vote to approve on the same basis. They've been open since July. No opposition. Community board did not respond, and ALJ says the applicant has met the burden. So I vote to approve.
Chairman Bradley.
I vote to approve.
Next
Under
item.
the same conditions.
Well, that's their method of operation.
Okay.
So, yeah. 632.
This is an Orange County liquor store in the town of Newburgh. 1,935 total square feet, 1,282 of that will be dedicated to retail. The principal owns 2 convenience stores in Dutchess, and his adverse history with those stores is he's got 1 sale to minor. There are 4 stores within 2.9 miles and 7 stores within approximately 4.6 miles. We do have some letters of support from individuals, one of which looks like he is the landlord, so you take that with a grain of salt.
Commissioner Ford.
No. Once again, no protests, which I find bizarre.
Yeah.
Commissioner Fan.
It seems like this applicant is already in operating businesses in the community. I actually really appreciated the business plan that he submitted, and also, even more so, really appreciated the letters he submitted from his employees. It shows a lot about his character and his business sense. So with that, since there's no protest and the closest store is 1.3 miles away, I find that there's public convenience in having the store, so I vote to approve.
Commissioner Ford.
Closest store is right down North Plank Road, 1.3 miles, but it's what is it? 15,000, 10,000 square feet, doing close to $10 million a year. But they are within a shopping district. This one is only 1,200 square feet. So I think I do find that they do meet the definition of public convenience and advantage. So I vote to approve.
Chairman Bradley.
I vote to deny. Based on this, there's 7 stores within 4.6 miles. It's a driving community, so that's a significant amount of stores to me. There's the closest store is on the same road, 1.3 miles away. The sales of 3 of the 4, well, we got no response from 1. 2 of the 3 that we did get a response to are showing either blatantly flat sales or a decrease in sales. And the population, while they say there's an increase in the population, I looked myself and found that there's no evidence of an increase at all. At best, the population is stagnant in the town of Newburgh. So I am voting to deny.
Next item, 633.
You ever been there? Mid Valley Wine and Liquor, big store.
No.
Newburgh?
No. This is a Kings County liquor store. 2,071 square feet. 640 of it will be retail. 4 stores within 0.4 miles. 2 stores within 0.2 miles. Not previously licensed. There is 3. The three of the 4 closest have protested. It will be 2 employees. Principals will manage, and the principals appear to have no experience. And it looks like, I can't tell, but it looks like they're both planning on also keeping their current occupations, which they appear to be full-time jobs, so I don't know how that's going to work.
The opposition also submitted a petition, which the applicant in a supplemental report takes some issues with, and the applicant claims that their store will be different based on their offerings and education, the usual education-related wine-type arguments for public convenience.
Commissioner Fan.
Third Avenue in Bay Ridge is a really busy corridor. The closest stores are 4 blocks and 5 blocks away. And, since one of the applicants is a location scout for productions, I imagine that he may be working at the store more than he thinks he will be. And with their business proposal that's going to focus on women-owned producers, and they're saying that they are not going to sell name brand liquor, so I'm going to hold them to that. But with that, while it's a post call, I'm going to vote to approve.
Commissioner Fan, you say you're going to hold them to that. Are you putting any specific condition on the license?
I mean, if the other 2 commissioners agree, I will say no name brand liquor, but, I realize it's not something that we want to do, so.
It's not that I wouldn't want to do it, it's such a gray area, I don't know how we would define what a main brand liquor is.
Name brand. Yeah.
Name brand, I mean. It's which one is and which one isn't.
Yeah, no, I'm with you. So, no actual restriction, but that, they should stick to the business plan they presented.
Commissioner Ford.
Closest store, it's only 3 blocks away, and it seems like the total space will be 2,071 square feet with 640 retail. Seems like a warehouse. I mean, it's twice the space of retail devoted to storage. More than that. No, about twice that amount. No, 3 times that amount.
Correct.
Twice. So, and I'm looking at the sales, and I think everybody is kind of flat or declining, so I'm going to vote to deny.
Chairman Bradley.
So just to be clear, Commissioner Ford, the reason that there's so much devoted to storage is because half of the square footage is in the basement, which will all be storage, and then they do have some storage in the back. So it is more than half that will be storage, you're correct. I'm going to vote to deny. The sales of the closest stores are flat or decreasing in 3 out of 4 of them. There's 12 stores in Bay Ridge already, and Bay Ridge is a small community. There's 4 stores within 0.4 miles, which is all, at best a less than a 10-minute walk. There's no evidence providing anything that any product or service that the other stores are not already providing will be available at this new one. And once again, we have an applicant that is telling us that the population is going up in Bay Ridge, which is I find hard to believe, and I've looked at projections, and at best this area looks like this population is projected to be stagnant, although since we haven't had a census in 10 years, it would be impossible to know.
I wonder how much we're going to be able to rely on a census that's being taken. I mean, we encourage everybody to respond to their census applications, their census notices, but we're going to have to consider.
It's all online this time for the first time, too.
Yeah.
Next item, 634.
This is a new package store in Manhattan on 5th Avenue. There are no protests, which, once again, I find how is that possible. There are 4 stores within 0.6 miles. The closest store is in 0.2 miles. There are 2 stores within 0.2 miles. And these are driving distances, which means the stores are probably closer. It appears there are 7 stores within walking distance, 4 employees, principal to manage. The principal does have experience. He did have a liquor license. A grocery store license that was surrendered in 2015. The store is 3,700 square feet. 1,000 of it will be retail.
Commissioner Fan?
There's a store that's really 1 avenue over, and another store that's 1.5 avenue over on the other side. I don't know. The application doesn't really have, a lot of support information, so I'm going to vote to deny.
Commissioner Ford?
Closest store, sales over $3 million. Next closest store, sales well over $1 million. Granted, there are quite a few stores in the area, but I think this is probably okay looking at everybody else's sales. So I'm going to vote to approve.
Chairman Bradley?
I'm going to vote to deny. There's 4 stores in 0.6 miles. The 2 closest stores are in 0.3 miles. One is showing a decrease in sales. The next one is showing a slight increase, and the third store is showing, which is 0.3 miles away, is also showing a decrease. There's 7 stores based on my looking at the area within walking distance. They haven't indicated that they're going to provide any products or services that are not available already in the other stores. So I just don't see any public convenience and advantage, so I'm voting to deny.
Next item, 635.
This is a enforcement case after hearing. 42 charges. Tonic East on 3rd Avenue in Manhattan. Sustain 1, sustain 2, withdraw 3, dismiss 4, sustain 5, dismiss 6, sustain 7, 8, and 9, withdraw 10, sustain 11, dismiss 12, withdraw 13, sustain 14 and 15, dismiss 16 and 17, sustain 18, dismiss 19, sustain 20 through 24, dismiss 25, sustain 26 and 27, dismiss 28 and 29, sustain 30 through 39, dismiss 40, sustain 41, and dismiss 42.
What was that?
Dismiss 42. Didn't I say that?
I didn't get all those. Could you go over?
That's what I was doing. We were all making the same joke.
The representative for the licensee would like us to take $15,000 or $15,000 right now and says he will pay it even in these circumstances.
The license was surrendered in October 2019, and the representative also says that they do not intend to reopen.
So they just don't want a cancellation.
They don't want a cancellation.
Plus, the licensee has 2 other licenses, correct?
Oh, so they don't want a revocation, is what they don't.
Commissioner Fan?
Where do you see that?
I will take the 15,000 since the location is already closed.
If you're opposing 15,000, Commissioner Ford?
I'll take the 15,000 as well.
Well, we're not taking anything.
Right.
This is after hearing.
You're opposing 15,000.
Yes.
Is that correct? Yes.
Yes.
Chairman Bradley?
I would have taken 25.
No, you would have imposed 20.
Imposed 25, I'm sorry.
Okay.
But it's 15.
But your vote is still to oppose 25?
Yes.
Right. Okay.
No, not opposed 25. I'm
Imposed.
imposed, right.
That's what I said. Yeah. Next item, 636.
And just to be clear, that place should have been canceled. So they got a gift here, regardless of the amount of money.
And I completely agree.
Yes,
This
agree.
is a Kings County Liquor Store on Flatbush Avenue. No employees, the principal and manage. It is not bulletproof. The principal has no experience. There are 4 stores in 0.7 miles. There is a store nearby on the same street that's also not bulletproof. It looks like none of the closest stores are bulletproof. It's 800 square feet. 600 of it will be retail. Now, there is a store at 2088 Flatbush Avenue, which is 0.3 miles away, called Brooklyn Synergy. And that, Adam, I asked you about that?
Is no longer in business.
No longer in business. That was shut in 6 of 2019. But we did already replace it with one of the closest stores nearby.
That would have been Revaya?
Yes.
Okay.
So then, Commissioner Fan?
It's interesting. This applicant seems to have found a location that is half a mile away from the closest stores in all the directions. I support her will to make a career change. So I vote to approve.
Commissioner Ford?
I'm going to vote to deny. One store is just licensed to replace the other one that closed, and another one just took over. So I'm not sure that I see the need. So I vote to deny.
Chairman Bradley?
I'm actually going to vote to approve as well, only because I think Commissioner Fan is correct that she does seem to have found a spot that is a significant, in Brooklyn, I should say, a significant distance in Brooklyn away from her closest competitors. And the closest store is 0.5 miles away, and the next ones are 0.6, 0.6, and 0.7 miles away. So I think just the fact that this particular area does not have a store that's closer is public convenience, and I do support her changing her career.
All right, the next item is 637. I would note that on after 4 o'clock on Friday, we received a submission from the applicant's new attorneys. I don't know when they were retained. The applicant was notified of this board date on April 23rd. So it was submitted late. It was rejected by the Secretary's office. And the attorney is asking that it be held over so that the submission can now be timely.
That's fine with me.
I'm just going to get a refund if we deny it.
Commissioner Ford?
I'm all right to hold it over to the 27th as well.
Chairman Bradley?
I'm okay. Going forward, that would not be held over.
Next item, 638.
This is a Rensselaer new on premises. It's actually a place that we did a summary suspension at because of sales to underage, and then we kept it open after the charges were filed, and a fine of $30,000 was paid. It's a tavern with 4 employees, no security, managed by the principal, jukebox music only. Applicant is the son of the current licensee, which is the licensee that had all those charges. The applicant was a bartender for the current licensee at the time of the underage sales. They have not had any problems since that, which was since the underage sales, which
July
was
19th.
July of 2000. Was it July or?
The fine was earlier, but it wasn't paid until July.
No, but the incident was April, correct?
The
incidents were April 19th. They don't April of 2019. They don't have a significant underage history. That looks like an anomaly for whatever reason.
Yeah, but they were closed from the time of the suspension until...
No, I'm talking about though from
until July when they paid the fine.
They had Sarah Myers in 2011 and 2002.
Right, but nowhere near the number they had here. So it looks like he's just transferring this to his son. I imagine that now the son is only 21 years old, but has been working there for several years.
Commissioner Fan?
Yeah, I'm on the fence about this one. You know, given their history, I'm surprised that they did not submit this application with an actual security plan. You know, on page 15, it just keeps repeatedly referring to, I will prevent sales, and I will make sure that patrons get home safe. You know, they say that get home safe a couple of times, but there's no actual description of how they plan to do that. So I appreciate that this is a family business, and I don't want to take that away from them, especially at this time. So I will say that if we were to approve this, we're going to need to require scanners and security cameras out in front.
Did we require anything with the last discipline?
We probably did.
It would be on the agenda sheet that you have in here.
Yeah.
If they were using it, it's not mentioned in the supervision plan provided. It says that you will train employees on how to identify fraudulent IDs.
They had.
Right.
So
If
so
this
what
person
happened?
himself made 13 of the 29 sell to minor, I'm not really sure if he's actually qualified to train anybody else on this.
So with the summary suspension case, they offered on paper cancellation of bond claim. They came in and then argued for something less, and you came up with $30,000, and you required the purchase of an ID scanner for the current licensee.
Yeah, so there's certainly no...
So Commissioner Fan, you're approving it subject to they have to have a scanner and security cameras, or just a scanner?
Scanner and security cameras in the front, yeah.
Commissioner Ford?
Chairman, was this the one who that was referred to us by, was it RPI? School called us to let us know students were there drinking?
No,
Not this one?
no. But this is an old school place in Troy. It's been around a long time. So I wouldn't be surprised if that RPI people end up going in there.
Yeah, okay. We did authorize a penalty of $30,000. We accepted it, and last July, and so we don't have no referrals or anything like that since then. So I'm okay to approve under the conditions that Commissioner Fan added. Plus, I want to add one thing more to it. I'd like to see a more detailed security plan, period. Doesn't sound like they really submitted one, other than saying we're going to take care of it.
Well, okay, so Commissioner Ford, you just want them to submit a plan, or
Do you want it to be approved by licensing?
Yes, approved by licensing.
Commissioner Ford, Commissioner Fan, rather, are you okay with that extra condition?
Yes, please.
Chairman Bradley.
Yeah, I'll approve under the same conditions.
Okay. Next, we have 639.
This is a Rocklin grocery store beer wine products license to gas station with 2 employees. The principal will manage. He has previously managed a 7-Eleven store in the past. There is a adverse history at the location. It was canceled in 2019. And the previous licensee that got canceled has a $15,000 promissory note with the applicant related to the sale of the business, which is open now.
Are they open now under a temp?
No, I don't. There's no alcohol now. It's just open as a gas station convenience store.
Okay.
Correct.
No other relation.
There is a temporary permit issued in October.
There is a temp.
Yeah, and no referrals. Not that we always get them for grocery stores, but.
So, Commissioner Fan.
I vote to approve.
Commissioner Ford.
I vote to approve as well.
Chairman Bradley.
I vote to approve.
Next item, 640.
This is a Bronx new OP. The applicant has a license with no adverse history, also in the Bronx, that's been open since 2013. It will be a bar tavern, 6 employees, 1 security guard or more as needed. The principal will manage. She's seeking recorded DJ, karaoke, and live music, no dancing.
I would say the rep submitted a supplemental letter saying that they are taking back the no dancing, so now no dancing, no DJs, no promoters, no hookah. So that would just leave recorded music and I guess live music.
Yeah, she said bands on occasion, but that sounds like live music.
And closing hours would be Sunday to Wednesday at 2 a.m.
And she's not going to use the DJ booth. The prior licensee here has the adverse history, and I don't under. She says she's going to be here full time, which I don't know what that means about her other business. I get the impression that no, she says she's not going to continue her current occupation. So does that? I'm assuming that means she's closing the other place.
Well, she indicated she'll hire an assistant manager with suitable ABC experience to manage both of the bars.
Okay. So that's
either.
So she is keeping her current.
Yeah. So either the applicant, principal, or an assistant manager will be at one of the premises at all hours.
All right, so Commissioner Fan, with the adjustments made by the representative's letter, are you ready to vote?
I will vote to approve the license for 2 a.m. across the board, no dancing, no promoter, no DJ. Security guard as needed, no promoters, no hookah, and a manager as needed.
All right, so Commissioner Ford then, as modified by Mr. Springer's letter and then by with Commissioner Fan's added conditions. The 2 a.m. security guard is needed, manager is needed. What's your vote?
Well, I see the community board steps. I can continue talk English really. The community board application here, but I don't see that the steps were issued or accepted.
Well,
Does anybody else?
No, it's not a 500-foot case, so they may not do that. I don't know.
Okay, all right. In that case, then I approve based on the previous conditions stated.
Chairman Bradley.
So we have no DJ, no karaoke, no live music, no dancing.
No. There is live music.
There is live music. There's recorded music. There is live music. That's the only entertainment.
No DJs dancing.
Right. There's 2 a.m. across the board. That's what Commissioner Fan is. Security guard is needed. Manager is needed.
Okay. And no
Yes,
promoter.
because the application said live band once in a while, so I'm going to go with that.
All right. I'll approve it.
Next item, 641.
It's the Monroe County Grocery Store beer product license. 2 employees, principal will manage. It's in the city of Rochester. The prior license was canceled because the prior licensee allowed an availee to take over the license. The former licensee is still the landlord and holds a promissory note with the applicant. Other than that, there doesn't appear to be a relation.
Well, actually, the party to whom the license was availed that led to its cancellation originally made an application, and then he sold that corporation to the current applicant and has a promissory note in connection with that sale.
So there's no connection to the prior licensee. The connection is to the prior
availee.
Yeah, who's the landlord and who holds the note.
And the former licensee is the landlord, right?
No, the former applicant.
Oh, he owns the building too.
Yeah.
Oh, that is a problem. I didn't see that.
And they have the same last name.
Really? No.
They don't. I think that's why I didn't see it. And he's not borrowing.
Oh, no. He has the same last name as prior licensee.
Correct.
Yeah.
Gamal Jamil Shaibi and the other is Jamil Shaibi.
Yes.
They have more than one name in common.
But not related to the availee.
To the available. So,
I guess not.
right.
There seem to be connections to both the availee and the landlord. And the prior licensee.
Yeah, this is a problem.
So, Commissioner Fan.
Yes, I agree with Council's assessment of this application, and with that, I vote to deny.
Commissioner Ford.
I'm going to vote to deny as well. I'm not sure that I believe everything is copacetic here, so I vote to deny.
Chairman Bradley.
I vote to deny too. The former licensee and the availee obviously had some funny business going on, and now the current applicant has a business relationship with both of them. So I don't think that that's a good idea. So I'm voting to deny.
Next item is 642.
This is an Onondaga liquor store in city of Syracuse. It's 2,624 square feet. 2,335 will be retail. There's 2 protests. This store is actually inside of a shopping mall, not like a plaza. It's in a shopping mall that you have to walk into to get into the store. I don't believe there is another entrance, correct, Adam?
No, it's through the mall at that level.
4 employees, principal to manage. The applicant has no experience. He's currently the president of a taxi company, and it looks like he still will be if he gets this license. There's 4 stores within 2 miles. The closest store is 1.2 miles away.
Commissioner Ford, are you familiar with the Destiny Mall?
Oh, yeah, very much so. I built a cell site on the roof. I know it very well. It's the largest mall in between Rochester and Albany, between Watertown, North Country, and Binghamton. It's gargantuan, and I'm surprised that there isn't a store there already, to be honest about it. So it's got all the major anchor stores there, closed right now, of course, but it's a pretty big mall, pretty big place.
Okay.
The application
So
also says, I was just going to say, the application also says there are 4,000 employees in the mall.
I believe it, yes. I would unquestionably vote to approve this if everything else looks okay with everyone else.
Absolutely. Okay, I vote to approve. Yeah.
Chairman Bradley?
I vote to approve just because it's inside the mall, so it's their entire customer base is going to be mall shoppers, and the closest store is a 10,000 square foot store, which is obviously a destination location.
Next item I have is 640.
Just to give you an idea too, it's the only Apple store between Rochester and Syracuse as well, Rochester and Albany as well.
Next item I have is 643. If you want to take out 648 as well, it's the same licensee.
Bless you. So 643 is a no contest. Bless you. Is a no contest default.
COVID droplet. Careful.
On two charges of failure to notify change in fact from February 2020, and 648 is exactly the same thing.
Yes, he has 4 arrests for misdemeanors. It looks like he's picking up passengers. Well, he's been arrested for picking up passengers at the airport 4 times illegally.
Yeah, every one of these arrests is on a separate date, about 3 months apart.
So for 643, Commissioner Fan?
I'm at 750.
Commissioner Ford?
I was a canceling bond
Chairman Bradley?
for both.
Let's see what he does.
Well, for 643, because Commissioner Fan, we're just voting on 643 right now. You're at 750, so Commissioner Ford, for 643, where are you at?
I'm at canceling bond.
Okay. Chairman Bradley?
750.
All right, and then for 648,
I'm also at 750.
and Commissioner Ford?
I was also at canceling bond.
Okay.
750.
All right, then. Just give me a second. All right, then. The next item, 644.
This is a Brooklyn grocery store beer wine product application. It's the third application by this applicant here. The applicant availed the license of the former licensee here, and the next application was withdrawn before decision. It's a grocery store with 1 employee, applicant to manage. It is open now without a temp, Adam? I don't think you would have gave him a temp.
No.
Yeah, he's been open for 2 years probably since he bought the place.
Yeah, so he's had this place without a license for 2 years. Because he availed it is
right.
Why he did that.
All right, then. Commissioner Fan.
Yeah,
He withdrew it.
Commissioner Fan?
Yeah, sorry, I thought Commissioner Ford was going to say something. Yeah, I mean, this. I really respect this applicant for hanging in there for 3 years and didn't really try to, operate in a different way. A lot of people would by now have found a front man and tried to do it that way. So I think 3 years is long enough. I vote to approve.
Commissioner Ford.
And he did withdraw the previous application so he could fix an issue and not have it be an issue for him, which was the entrance and exit. So there's no physical connection between the premises and the restaurant next door. So I vote to approve as well.
Chairman Bradley.
Well, the two of them have me just feeling good about myself, so I'm going to vote to approve as well.
Punishment enough.
I wouldn't be getting it. They're making me become less hard.
Any availer is starters out for life.
Yeah.
The next item, 645.
This is a Erie County new liquor store in Depew. 0 employees. The principal will be the sole employee. He's a former worker at Southern Wine and Spirits, which is a major wholesaler. It's 1,100 square feet. 784 square feet will be retail. 3 protests. And there are 4 stores within 1.7 miles. The closest store is 0.6 miles. The 4th closest store is 1.7 miles away, and we opened it in 2017.
There are also letters of support from Senator Gallivan, the mayor of Depew, and a few business owners.
Correct. And the business owners, I'm sure, were former clients of his.
Yes. There's also a point made in the protest letter that the SLA has denied licenses in this general area in 2016 and 2018 based on the number of and square footage of licenses within a few miles, within 3 miles.
Commissioner Fan.
While I really support this applicant in having her own store, she obviously comes with a ton of industry experience and relationships, and compliance hopefully will not be an issue for her. I imagine that since the 2 close stores are already doing lowering numbers past 4 years, and there is a store that is 0.6 miles away, I think perhaps this applicant needs to find a different location. So I support her in her endeavor to open a store, not at this location, so we're not denied.
Commissioner Ford.
I am muted here. Good. Okay. There's support from Senator Gallivan, the mayor of Depew, Kevin Peterson. The store is only 784 square feet of retail. Other stores are 2,400 to 3,500 retail. And I'm surprised that there isn't some sort of store within the heart of Depew anyway. It's pretty populated area, so I will vote to approve.
Chairman Bradley.
I'm going to vote to deny. There's 4 stores within 1.7 miles. I think there's something like 8 stores. 8 stores within 2.8 mile radius. The population appears to be at best stagnant in the area. I don't see any products or services that this applicant's going to provide that the other stores don't provide already. The sales are either flat or down in all the 4 closest stores. And I agree with Commissioner Fan. It's a great applicant. She clearly has a background in the industry and would probably run a good store. It's just I don't see the need, and I don't see any public convenience and advantage, particularly since we just opened one in 2017 and have denied many in the recent previous year.
And next item, 646.
This is an Erie County wine store in Marilla, New York. 4 employees, principal and manage. No one has any experience. There's 360 square feet devoted to retail, 445 total square feet. It's very small. They say they will only be offering New York State wines. The closest store is 4.7 miles, and there are 4 stores in 8.9 miles. There is one protest from Alden Wine and Liquor, which is a store, which is the closest store, and just opened in 2019. and it's when I say closest, it's 4.7 miles away. It's in a completely different town.
And it's in a shopping plaza, I believe, whereas this one is at a crossroads, literally in the middle of nowhere.
Yeah, I mean this. Given that they say they're only going to only sell New York State wines, this is obviously a niche store. And you only go there to get New York State wines.
Yeah, it's a flower store. They're subdivided. They're already there.
Commissioner Fan.
I guess a lot of people are going from flowers to alcohol. This is like the third person that's going from doing that.
Well, they're not switching. They're just cutting the store in half. Or actually,
okay.
Flower and souvenir shop. They're putting up a wall to add a wine store.
I guess the tourist population in Marilla went down, so there was no souvenirs to sell.
All right.
Buy a little.
The store is 4.7 miles away. I find that there's public convenience in having the store, so I vote to approve.
Commissioner Ford.
I vote to approve as well.
Chairman Bradley.
I vote to approve, but they're being held to their method of operation that they put on their application, which is wine only from New York State. They offered that. We didn't. We're not imposing it.
All right, so Commissioner Fan, Commissioner Ford, you want to make that clear? Are you going to make that clear too? The method of operation is New York State wine only.
We can do that, right?
That's fine if that's what they said. That's what.
Yep, that's what they. Yep.
Yep, that's what they applied for.
Can we take 2 minutes?
All right,
Yeah.
we're going to take a brief recess at 12:16. All right, we're back on the record now after a brief recess, and we are on item 647.
This is a Queens, new OP in Queens. The CB is okay with it. It is a bar, 4 employees, 1 to 4 security. Principal will manage DJ, karaoke, and recorded music. There are no protests. This is a strange one because we previously approved this applicant with conditions. They never met the conditions of the approval and now wants the license again, but he wants this license with no conditions. The previous license conditions were, I believe, 1 a.m. Sunday to Wednesday, 2 a.m. Thursday, 3 a.m. Friday and Saturday. No promoters, no live music, and no lines outside. He now, through his representative, indicates that the community board has approved the no conditions on this application, but I don't see that approval. I see that they approved the license, but they didn't talk about closing time in their new letter or anything.
They voted not to oppose back in a year ago.
Correct.
Do we have anything more recent than that?
No.
Are you referring to me? Okay. Oh, yeah, May 16th, yeah. No,
That's what I'm talking about. That letter is the one saying that they voted not to oppose, and I don't see that as endorsing a 4 a.m. across the board.
Yeah, this is an interesting application. I would think that, I looked at it, the menu that was submitted, while they say come and enjoy a taste of the Caribbean, there is a one-pager, but what looks like just Chinese food.
What kind of food?
It's Chinese food. The menu they just submitted is noodles and fried rice.
You're right.
For the
chow mein. No, there's several chow mein and lo mein dishes there as well.
For the record, they did file as a bar tavern, so they aren't held to the same stat.
No, but she's right. The menu is not a Caribbean menu.
Yeah, so I don't know.
They have jerk chicken. That's about it.
And since the applicant has no experience, and this is a residential block, heavily residential block, I would only really be comfortable approving a bar tavern with 4 employees, security as needed, recorded music only, which means no DJs, no karaoke, no dancing, no promoters, and 2 a.m. across the board.
So you change you're not going with what was originally approved. You're just going with recorded music only now and 2 a.m.
Yeah, well, we didn't approve it. It was the board in 2016 that approved it.
She didn't. She's right. What? But she could change it. There's nothing wrong with it.
Commissioner Ford?
I'll approve on the same basis. I was going to go 1 during the week and 2 on the weekends, but I'll go with 2 across the board.
So 2 a.m. and recorded music only.
Yes, sir.
Chairman Bradley.
Now, I voted to approve this thing last time, and I don't think Commissioner Fan was here at the time. So maybe that's why I didn't notice the menu. But the menu to me is enough reason to not even approve anything. This is a joke. Now, I realize they don't need significant food, but this is not. If you're going to tell me that this Caribbean restaurant is serving 16 different chow mein and lo mein dishes, I don't believe it for a second. This thing is completely made up. And I don't know whether that's the applicant's issue or the representatives, but the fact of the matter is that it looks like they threw in the local Chinese restaurant's menu into their application.
Next to a page that says, "Come enjoy a taste of the Caribbean."
Exactly. But in spite of the other two commissioners voting to approve it, I'll approve. In spite of that, I will approve with Commissioner Fan's conditions.
Okay. Next item is 6.
And excuse me, you're correct, Chairman. It was just you and I the last time that voted to approve it.
Which is why I probably didn't notice the pathetic menu.
Next item is 649.
This is a Kings County bar conditional no contest for 12 charges. They're seeking a $25,000 penalty. There are, as I said, 12 charges. Of the 12, 8 of them are disorderly premises for having a controlled substance. The controlled substance in each instance was ketamine.
Let me remind the members of the record here. This came to the board previously, and there was a lack of alignment between the charges and the opinion, and it was because the judge, the ALJ, had relied on an earlier notice of pleading. It may have been the judge's error, it may have been counsel's error. So we returned this case. The chairman asked that the case be not only returned to reconcile that, but also to get a more lengthy description of the evidence on some of the charges that had not been sustained, based on the ALJ's conclusion that there was no test of the controlled substance offered into the record. So while that was pending for the ALJ to re-review, they offered $25,000 as a civil penalty to settle the whole case, which would mean the rulings wouldn't matter. It would just be a CNC for $25,000.
And
so if this is rejected as an offer, it will go back to the ALJ to finish her hearing opinion with those requests, and then come back to the board for discipline.
And most of the hearing is finished, correct?
The hearing
we do have some sustained charge in this.
The hearing is finished.
Right. There's one charge.
So there's the focal point charge was sustained. The failure to supervise charge was sustained. 2 of the disorderly premises controlled substances charges were sustained. There was a gambling device charge that was not sustained, although I was going to recommend that the board take a close look at that one because the ruling was questionable. So we didn't get to that, but that's something we would get to if this offer is rejected and it comes back.
Okay.
So, Commissioner Fan?
I will accept the $25,000.
Commissioner Ford?
It was all a while ago. No other charges since then, and I'll take the offer as well.
Chairman Bradley?
I would have taken cancel. If the hearing came back, it would have been revoked. That's obviously a drug den.
Next item is 650.
This is a enforcement CNC from a Onondaga County OP in the city of Syracuse. It is an enormous amount of sale to minors, and the offers cancel the bond, as well as other charges, but the significant charges are the sale to minor.
I would take cancel and bond.
Commissioner Ford?
Cancel and bond.
Chairman Bradley?
Cancel and bond.
Next item, 651.
This is a CNC for a Monroe County OP, false material statement, availing in books and records. The offers cancel and bond.
Commissioner Fan?
Cancel and bond, accept.
Cancel and bond, accept.
Chairman Bradley?
Cancel and bond.
652.
This is a King's Tavern wine license, Kings County Tavern wine license. It's no contest default at hearing. The license has already been revoked earlier due to previous charges. So
Commissioner?
there's no bond available.
Commissioner Fan?
Revoke for the record.
Commissioner Ford?
Cancel for the record or revoke for the record?
It's up to you.
Revoke for the record.
Okay. Chairman Bradley?
Revoke for the record.
653.
This is a Queens OP change in method of operation in the Ridgewood section. They are seeking to go from 2 a.m. Monday to Thursdays and 4 a.m. on Fridays to Sundays. They're seeking to go to 4 a.m. every day. The CB was not notified of this change in method of operation, so they did not have input.
No, they did. The supplemental has a letter from the community board saying that they do not want the change on the weekend hours.
We just received as a supplemental. They weren't notified. They weren't notified by the licensee.
How'd they find out about our calendar?
We notified them.
Okay.
Secretary's office.
Oh, I see. Sorry about that.
No, I didn't read. I didn't see that back. I didn't see that letter. I have it. I didn't read the back of it. All right.
Community board's input, I vote to deny.
Commissioner Ford?
I vote to deny as well.
Chairman Bradley?
I vote to deny, but I'm going to make this proposal that if they do go and get the community board sign off, that the licensing board can grant this, assuming that the community board agrees with it. So they can reapply. And that wouldn't have to come here.
Okay. Commissioner Fan, are you okay with that?
Sure.
Assuming that the community board agrees to the 4 a.m. across the board only. If it doesn't, then it comes to the board.
Well, they just wrote a letter on May 7th saying they don't agree with it.
Right, but they also weren't notified, so they never had a chance to talk to them about it.
Oh, I see what you're saying. Okay, yeah, that's fine.
All right, so if there's a new application that on notice to the community board doesn't oppose it,
no, they have to affirmatively say.
Affirmatively, okay.
Yeah.
Then it can be acted on by the licensing board.
Yes.
Okay. Commissioner Ford, are you okay with that?
Yes.
Okay. Next item is 654.
This is 6 charges after hearing of a Manhattan on-premises license. It's been adjourned a couple times. So dismiss 1 and 2, sustain 3, 4, 5, dismiss 6. This is somewhat frustrating to me the way that this attorney conducted this hearing. Or not the hearing, but the investigation. But I'll leave that to you.
Yeah, well, I actually held this over because I was concerned about the judge's ruling on charge 2, and because the ALJ did not include enough detail in the record, I went back and looked at the transcripts and such, but we decided not to put in a supplemental submission with respect to charge 2 and whether it should be reversed. So we think that the board should rule on the charges that were sustained.
Which I just did, but just to make clear that the licensees are required to answer questions in relation to the businesses conducted by their licenses, by our investigators as well as at a hearing. And going, in my view, should the situation that happened here where the attorney directed the licensee not to answer questions during the investigation, should that happen again, I'm going to be revoking licenses. And I would recommend that you put the licensees on the stand. And if you have to do it every hearing, then do it. My office intends to address the situation in other ways, but did not believe that reversing the charge was the way to go about it here.
All right. So Commissioner Fan.
Because of the date of the violations here and the date of charges of a prior case where this licensee was paid $50,000 for those 3 charges of failure to supervise security guard and manager, I will take $3,000 for this.
Commissioner Ford.
I'll accept that as well.
Chairman Bradley.
I'll accept, but that's it. That's the end for them.
All right,
They end up in front of us again.
Can you go on mute for a second?
all right,
I mean, not accept, I'll impose
all
3,000.
right, we're going to have a brief recess.
Oh, sweet. Thanks, man. I'm almost done now. Oh, sweet.
You're not muted, Commissioner Fan.
Oh, sorry. My husband brought lunch.
He's a keeper.
Indeed.
Right, go
All right,
ahead.
we're back on the record after a brief recess. We just concluded item 654. Now we're going to proceed to item 655.
So this is a on-premise in Kings County, New York, that's been adjourned on multiple occasions in order for our agent to go do a 200-foot measurement, which he did, and there's no question that this is within 200 feet of a location that says it's a church. The question now remains whether it's used exclusively as a church, because there clearly are apartments above the location that is the church part of the building. The problem with it is that our investigator went back twice and was unable to talk to anyone at the church or anyone in the apartments upstairs. So I'm going to turn to counsel here and ask what you suggest at this point, because it's clearly within 200 feet. They have not established it's not exclusively a church.
I don't think you can approve it if it's. I mean, it's not our job to make the case. I don't believe for whether or not this is exclusively a church, and we definitely went above and beyond in trying to find out the answer. But I don't know how we can approve a location that's less than 200 feet from a church when we have evidence that it's a church.
Okay. And we have no evidence within their application that it's not used exclusively as a church.
Well, the attorney did provide an affidavit stating the uses of the church to his belief.
To his belief.
Right. Whether or not what we want to take and put reliance on that is another question.
That's not going to happen. Not with me, at least.
All right, then. So with that, Commissioner Fan?
I vote to deny.
On the 200-foot issue, right?
Yes.
All right, Commissioner Ford?
I vote to deny as well.
Chairman Bradley?
I vote to deny solely on the 200-foot issue. There's, other than the affidavit of the attorney, which doesn't explain what he did to establish that this is not a building used exclusively as a church, and I don't believe he's established that it's not a church. So my hope is that it's not, so that they can get a license, but
Right.
I can't rely on what was given to us.
All right, the next item, 655A.
This is a Queens OP that is in Astoria. It's been adjourned a couple times. It's not a 500-foot case. It's a restaurant with 7 employees, no security, recorded music and DJ, no live music, no karaoke, max occupancy of 74. The applicant was denied 3 times at this location. One was for a drug felony arrest. A felony arrest. And then another was for drugs during the conditional approval. Place is currently open and has been since 2015. That means not on a temp, right, Adam?
Correct.
He has 2 convictions for drugs. Both ended up being misdemeanors. The work history of the applicant, since we've had multiple applications from this applicant, has not been consistent. In previous applications, he said he owned and managed a lunchbox cafe from 2009 to 2013. Now he says he was unemployed from 2004 to 2015. So I don't know what's going on there.
Commissioner Pham.
Thanks. Given that this is only a family restaurant and it's been open for 3 years, and the supplemental material suggests that he has 11 employees, I am going to vote to approve, but the hours will be midnight only across the board. Recorded music only, no DJs, no live music, no box, no karaoke, no dancing, no security, and no manager.
Commissioner Ford.
I'll vote to approve on the same grounds.
Can you read the grounds again?
Okay, so you have the method of operation, which is in the memo, and the 2 changes would be 12 a.m. closing and recorded music only, no DJ.
Okay. I'll approve on those grounds.
With that, I have nothing else. Do you have anything else, Chairman?
No.
All right, then we are adjourned.